started. And then that way, if you or any other agents in your office would like to access this recording, just shoot us an email and we would be happy to provide that. This will also give us a couple days, but this will also be posted to our YouTube channel as well. So it's there for you whenever you would like to access it. And I do have a PowerPoint. So let me share my screen and we will get started. All right, so today we are talking about the unlicensed practice of law, and we're going to go through some material that's a little bit dry and through the actual statutory language, but I promise I will tie this all together for you with some practical examples and tips and advice for you in your business. So the unlicensed practice of law is regulated by the Florida Bar. That is an official arm of our Florida court system. And what they do is they receive complaints for the unlicensed practice of law, and then they proceed with investigating and, if necessary, prosecuting those complaints. If you experience another agent engaging in the unlicensed practice of law and would like to make a complaint of yourself, for yourself, you can do that at floridabar.org. So let's take a look very quickly at the statutory language. It is found in Florida Statute section 454.23, and this talks about the penalties if you do engage and are found guilty of engaging in the unlicensed practice of law. The statute reads that any person not licensed or otherwise authorized, and that difference there will become important later, to practice law in this state, who practices law in this state or holds himself or herself out to the public as qualified to practice law, or who willfully pretends to be or willfully takes or uses any name, title, addition, or description, implying that he or she is qualified or recognized by law as qualified to practice law in this state, commits a felony of the third degree. So that was a lot of legal language that probably didn't make much sense, but the takeaway here is if you are found to have engaged in the unlicensed practice of law and you are not legally authorized to do so, that could result in a felony in the third degree, which is a very serious penalty. So I stated before, this is a little bit of a scary topic, and one reason why it is so scary is because the penalties can be very harsh. So I wanted to make sure that you are aware of that. But let's talk about what is the unlicensed practice of law. What does that look like? And again, we're going to start with the law, and then I will make it a little bit more practical for you with some examples. So the Florida Bar will engage in a two-part inquiry in order to determine whether somebody is guilty of practicing law without a license. The first part of that inquiry is whether the activity constitutes the practice of law. And we're going to look at a very specific definition of what constitutes the practice of law. And then the second part, so if the answer to step one is yes, the second consideration is, was that practice of law authorized? And just because you're not a licensed attorney doesn't mean you are not authorized in certain circumstances to engage in what would be considered the practice of law. And we will see that as real estate agents, you have more leeway and authority in this area than a non-licensed agent. Okay, so let's look at a more specific definition of what actually constitutes the practice of law. What does that mean? And I provided the Supreme Court case up here that provides this test for us. So here is the test that we need to keep in mind when evaluating whether certain conduct or certain advice would constitute the practice of law. So here it is. If the giving of the advice and the performance of the services affect important rights of a person under the law, and if the reasonable protection of the rights and property of those advised and served requires that the persons giving such advice possess legal skill and a knowledge of the law greater than that possessed by the average citizen, then the giving of such advice and the performance of such services by one for another as a course of conduct constitute the practice of law. Again, a lot of legal jargon in there that may not make much sense at first glance, but let's break this down a little bit. So the first thing we would need to look for is, does the service that you're providing affect important rights of another person? If we are talking about the sale and purchase of real estate, that is an important right of the other person. And so your services and your advice in connection with that sort of transaction does affect the important rights of another person. Then we need to look at whether the advice and or the services requires you to possess a legal skill or knowledge greater than that of the average citizen. Keep in mind that that is a very low threshold, because the legal skill and knowledge of the average citizen is next to zero. So as real estate agents, even if you're a very, very new real estate agent, it is a very safe presumption to make that you have greater legal skill and knowledge when it comes to real estate contracts and transactions than that of the average person. The third thing we need to look at is, are you giving the advice or performing the services for another person? So this just eliminates, basically, you can provide legal services to yourself. You can represent yourself in court. You can negotiate on behalf of yourself. You can create your own contracts. Where it could become problematic is if you were doing that for another person. So we are looking at, does the service or advice affect important rights of another person? Does the service or advice require you to possess a legal skill and knowledge greater than that of the average citizen? And are you providing this skill and advice for another person versus for yourself? And the Supreme Court did note kind of the public policy behind why we even care about the unlicensed practice of law is here. And they state specifically that the single most important concern in the court's defining and regulating of the practice of law is the protection of the public from incompetent, unethical, or irresponsible representation. So when we're talking about important rights of another person, and I say we, the Florida bar wants to prohibit people who are not qualified to give legal advice and provide legal service from doing that. That is the whole point of this. So let's talk about some examples, and these are all going to be related to real estate transactions. So the court has noted that the drafting of a real estate purchase contract is considered the practice of law. However, the Florida Supreme Court has provided an exception for licensed real estate agents. That exception is that a licensed real estate agent may prepare a contract for the sale of real estate, but that any other document must be prepared by an attorney. Now, there are some caveats to this. So we have the general rule that preparing a real estate purchase contract is the practice of law. Then we have an exception that says, but real estate agents are authorized to engage in that conduct and that service. However, there are some very specific exceptions to the exception. Welcome to our legal system. So here those are. I'll go through the language and then we will break it down. So if the non-lawyer is using a form approved by the Supreme Court, the non-lawyer may engage in limited oral communication to elicit the factual information that goes into the blanks of the form. The non-lawyer may not make any changes to the form and may not give advice on possible courses of action. So let's stop there. We are talking here about approved standard real estate purchase contracts. So that's going to be your FAR contracts, and that's going to be your CRISP contract. With those contracts, you are permitted as licensed real estate agents to have a discussion with your client, elicit the information that you need from the client in order to figure out, what are their priorities? What do they want to offer? What are their sticking points? You can use that information to fill in the blanks of the form purchase contracts. You cannot change the language of the standard contracts. You cannot cross out language and type in your own language. You're not even allowed to type into the additional terms section, and we'll talk about that as well as addenda, without that language being either prepared by or reviewed by an attorney. Additionally, not under any circumstances are you allowed to give advice on possible courses of action. So what that means is you're not allowed to say, if you don't cancel by the inspection period, they can sue you and they can get the deposit, and they can sue you to force you to go through with the purchase of the property. You're not allowed to advise on the consequences of what could happen if. You can review the contract language, you can direct their attention to resources as well as the specific contract language, but you cannot say this is going to happen if you do this or if you don't do that. Now let's talk about if we are using a form that is not approved by the Florida Supreme Court. So this is going to be a real estate purchase contract that's not a CRISP or a FAR. This is also going to be blank addenda. So there are some authorized or standardized addenda that are available for your use, but there's also a blank addenda floating around there that you can type in on your own. In those cases, the rule is if the non-lawyer is using a form not approved by the Florida Supreme Court, the non-lawyer may only type the blanks on the form with information obtained from the individual in writing. So when we're talking about standard forms, you are allowed to have a verbal conversation with your client, take that information and use it to fill in the blanks of that form. If we're talking about you filling out your own addendum or you creating your own contract language, the only thing you're allowed to do is take what your client has instructed you to do in writing. You have to have it in writing and regurgitate that information into the blanks or into the blank addendum that you're using. So be very careful when you're using that blank addendum or you're typing language into the additional terms, because unless you have that language verbatim from your client, which most often you're not going to, that is considered the unlicensed and unauthorized practice of law. There's other exceptions I'm going to go through just quickly. This next exception that relates to title companies. In this case, the Supreme Court held that a title insurance company can conduct closings and prepare documents incident to the issuance of title insurance, only if the company is actually issuing title insurance. So again, the conducting closings, preparing documents for closings, preparing deeds, all of those things are considered the practice of law, but there is an exception to where title companies, so long as they are the ones issuing title insurance, are authorized to engage in that particular form of the practice of law. And here are some examples: warranty deeds, quitclaim deeds, land trusts, leases greater than 1 year. There is an approved standard lease form, but it has to be for 12 months or less in order for you as a non-lawyer to legally prepare those. And then loan documents such as promissory notes, mortgages, and loan agreements. These things all constitute the practice of law. And then if you engage in any sort of property management for your clients, I want to briefly touch on evictions. So it is considered the unlicensed practice of law for a non-lawyer to represent a third party, such as a landlord, in an eviction. Generally speaking, a non-lawyer may not prepare eviction forms for another unless they're merely typing the information provided in writing by the client or the customer, or completing a Supreme Court approved form. Now, there is an exception to this for property managers. Property managers may fill out, sign, and file complaints for evictions as well as default paperwork, but only in uncontested residential evictions for the non-payment of rent. So the basis for the eviction has to be non-payment of rent. The eviction can be filed by a property manager. If the tenant responds and defends the eviction, the property manager is out. They can no longer pursue that lawsuit. If the tenant does not respond and the action results in a default judgment, that is something that a property manager can see all the way through. So there are some exceptions here, but it is a pretty restricted exception as far as evictions go. Continuing on with our statutory language regarding another example of unlicensed practice of law as it relates to real estate. In this case, a real estate licensee may be disciplined, including the suspension of his or her license, if he or she has rendered an opinion that title to any property is good or merchantable, except when correctly based upon a current opinion of a licensed attorney at law, or has failed to advise a prospective purchaser or consult her or his attorney on the merchantability of the title or to obtain title insurance. So basically, you cannot give advice to your clients as far as whether you believe title is marketable, whether title is clear, whether there's a cloud on title. You cannot give that advice. You can provide resources, so you can say, here's the title search, here are the liens that came up on the title search, but you cannot say this is going to prevent closing because it's a cloud on title. You're going to have to file a lawsuit for quiet title in order to clear it up before we can proceed. You are not allowed to have those sorts of discussions with your clients. Okay. That was a lot of information, and I know that I went through it pretty quickly. I'm going to go ahead and stop sharing my screen here, but I'm going to go ahead and open it up for questions, either about the topic presented or about anything real estate related that I would be able to answer for you. I like to speak on this topic, and I don't like to speak on this topic because I do understand how scary it can be. I also understand that in the majority of transactions where there are addenda involved, that realtors are filling out those addenda, oftentimes blank addenda, on their own without it having been reviewed by a lawyer. I know this type of conduct happens all the time. It largely goes unreported, but I still think that it is important for you to know and realize what you're allowed to do, what you're not allowed to do, and what those potential consequences are. I get a lot of questions about addenda and, what if the seller's just going to make some repairs after the inspection, they negotiate, the seller agrees, yes, I'll make some repairs. Do I have to hire a lawyer every single time? Because that comes up in, the majority of transactions. The answer is no. So one option is, and a lot of brokers will provide this for you, but one option is to type up your proposed addenda for common scenarios such as repair requests. Appraisal gaps are another one that it's becoming very common right now. Have that language reviewed by an attorney, and then you can use that standard language over and over and over again. You're just filling in the blank of the repair, the amount contributed, whatever those details may be. So this is not something where you have to go out, find an attorney, hire one, pay hundreds of dollars for every little thing that you want to include in a contract. But it is important enough that I think you should be aware of it and make sure that for common scenarios such as the ones that I just mentioned, you are getting those standard addenda approved by an attorney, and then you're free to use those moving forward over and over again. And many brokers will provide those for you, and they've already been vetted and approved by attorneys prior to them providing those. So what questions do you all have for me? Hopefully I didn't scare too many of you off. It looks like most of you are still with me. So.
Hi, Kristen. This is Christine Payton. Can you hear me?
Yep, I sure can.
I wanted to go back to the part where you talked about not being able to advise your client. Say, for instance, they decide they want to cancel the contract. You can't say to them there will be consequences or there could be a penalty of some sort. Like, how do you handle that?
So you can absolutely say there will be consequences. What you cannot do is tell them what those consequences are. You can also refer them to the language in the contract, and you can even read them the language in the contract related to that issue, which is very specific in most cases. So if they do not get approved for financing and the loan approval period passes, the contract is very specific about what will happen. So you can go through and read that language to them, say that there will be consequences. The contract lays out the consequences. Here's what the contract says. If you have any additional questions about what could happen or what sort of liability you may have because of this, you need to speak to an attorney. That's how I'd recommend you handle it, and always recommend in writing that they seek advice of an attorney. Most times, depending on the issue, they're probably not going to, but that's going to protect you as the agent in case they say down the road, well, my agent told me that I could cancel and nothing would happen, or whatever the case may be. We don't want to get you into those sorts of situations.
Okay, thank you.
Absolutely. Right. What other questions do you all have for me?
This is Cynthia. On the legal hotline, where sometimes we call if we have questions, and clearly it says at the beginning, you know, you cannot tell anybody else about this. So how is that handled? Like if we get information, how is that handled?
As far as if you present a question to the legal hotline, are you allowed to give the answer that they tell you to your client?
Well, I know you're not, because it says you're not, you know,
So the way I would recommend you use the legal hotline is to protect yourself as an agent in the transaction, not to figure out what should your client do, or now that something has been done, what are the consequences? But to protect yourself, how should I handle this? What sort of advice am I allowed to give? Should I stay involved and try to help them negotiate a settlement, or should I completely remove myself? You can ask those questions as far as the substantive issue goes, but not for the purpose of then turning around and advising your client, just for your own knowledge. And then as far as how you should handle it to protect yourself as an agent, that's what the purpose of that is. So I would still follow the same guidelines, even if you have reached out to the hotline and they have given you information. I would still comply with what I went through in today's presentation, as far as, you know, there could be consequences for this. Let's take a look at the contract language. If you have any other questions, you need to reach out to an attorney.
Cristen, this is Bill.
Hi, Bill. How are you?
Good morning. Good morning to all that are on the call. So when we receive offers for our listings from other buyers agents, they seem to be practicing law because they're always writing in something in the additional terms. How do we accept those, or we cross it out and write in our own terms that have been already accepted? I mean, does that violate something there in the contract when we receive it from a buyer?
So the fact that an agent has engaged in the unlicensed practice of law by filling in their own language, that does not affect the enforceability of the contract. So there's no argument that the contract is invalid, or even that portion of the contract that they have typed in is invalid because of that. I would recommend doing what you kind of hinted at, is responding with a counteroffer with your approved language on that issue, and letting them know that the reason we're countering is because we've gone to an attorney. This is the language that they recommend we use to accomplish the goal that you're trying to accomplish with this addendum, or with these additional terms. Of course, it is always up to you what you want to report or not report, but I would not, I would counter with the terms that you have that are approved, and then just realize that even if your client signs it as is and you don't counter with approved language, attorney approved language, that is not going to affect the enforceability of that contract.
Thank you.
Absolutely. Right. Other questions for me? And while we are waiting here, because I know you'll have more questions, I'm going to go ahead and put in my direct email address into the chat, so that if you have questions, if you have follow-ups, you have anything that you need at all, you have my direct email address. Every time I speak on this subject in particular, I get tons of questions. So I know you have them. Don't be shy, write them in the chat if you don't want to ask your questions verbally, but I know you all have questions, and this is also open to questions about anything at all. So transactions that you've had recently where maybe an issue has come up, or and you want to know how to, maybe you can handle it better, things that have come up that aren't necessarily urgent, but you're just curious about. I am here for you. This is free legal advice for you all, so take advantage of it.
I have a question, Cristen. So this is regarding a builder's contract, and not, it's very long. But the first and most important question the buyers always have is their deposit money. So the builders now, because of what's happening, really picky with the contracts that they're accepting, and that they want, they will have a financing contingency, but after that 30 days is up, then there's no more financing contingency. So the buyers, I let them know that that's the only time they can get their deposit back. Now, they have questions because what if? So if I answer any more questions about that deposit being returned to them only if their mortgage doesn't get approved, is that giving them legal advice?
So your advice to them is you can only get your deposit back if you get denied within that contingency
30
period.
days.
Right.
Because sometimes, it takes 12 months before the builder will close on them, and then something may happen with that mortgage, or something like that.
So I would definitely go through the deadlines in the contract. So that 30-day financing contingency period that you mentioned is one that I would make sure your client is aware of, and they know the importance of meeting the deadlines in the contract. They're all hard deadlines. If you don't cancel or do whatever you're supposed to do within the deadline, you've lost your right to do it. I would also review the language relating to the financing contingency period in the contract with them, because there is going to be language in there that says, if you cancel within the financing contingency period, the buyer is entitled to their deposit back. And then in the default section, there's going to be something that says if the buyer doesn't comply with their obligations, that they forfeit their deposit. So I would stick as close to the contract language as you can. I still think you can have that conversation, but I would not add anything additional aside from what is in the contract. And the contracts contain a lot. So all that you know about deposits and when they go to the buyer, when they go to the seller, all of that comes from the contract. It's in there. So to protect yourself, I would recommend sticking as close to that contract language as you can. And then if the questions are getting to the point where you feel uncomfortable or you think it may go beyond the written words in the contract, at that point, again, to protect yourself, I would say, I can't give legal advice. You should speak to an attorney, but here's what the contract says. You have a little bit more leeway to say things when you preface it with, I can't give legal advice. This is not legal advice, but just in general for this issue and all issues, stick as close as you can to that contract language, and everything you need in most cases is going to be within that contract.
Okay, because there's a lot of money involved with the builders wanting 20% or 15% down. And then the contract will last, 12 months, let's say 10, 12 months because of delays and things like that. So their worry, or at least what they have told me, is what if something happens between that initial 30 days where they're approved for the loan, and then, that next 6, 7, 8 to 12 months where something happens and they can't get the loan for whatever reason, what happens with that money? And I say, well, you only have 30 days to get your deposit back. After that, there's no more contingency.
And that's correct. And that's exactly what the contract says. So my response would be the financing contingency period. That is the amount of time that you have to cancel this contract due to a denial of the loan. If your denial of the loan comes outside of that financing period, you are no longer entitled to the deposit. And that is right here in paragraph whatever titled financing. You can tell that to your client because that language is in the contract.
Okay.
Now that
Thanks.
doesn't resolve the problem of I get approved within 30 days and now I got to make sure nothing happens to affect that approval for the next 10 months. That's certainly an issue. And the result is, you know, or the answer is if you don't get your loan approved at close by the time of closing, you're in breach of the contract and you don't get your deposit back. There's no ideal way to handle that from a buyer side because the builder in this case has so much invested in customizing a home for this buyer. That is their damages. That is what they get to compensate them for investing and building this home to those requirements and those specs. And then they now have to go find a new buyer that wants that exact same home. We all know in this market that that's very easy for them to do, but that is the whole idea behind it. And there's really no getting around that. I've attempted many times to negotiate new construction contracts. And for the most part, the builders are like, people are begging me to build them houses. You sign the contract as is, or you find a different builder. So there's not a whole lot, unfortunately, we can do to protect the buyer more in that situation.
Thank you.
Sure, thanks for the question. Right, what other questions do we have?
Do we have that list? You said there are certain things, and I wasn't able to go to the last meeting, so you might have discussed it then. But the real common things like now with the appraisal gap, I mean, do we have, you know, certain things that you have already approved, like a list of them so that we could just kind of hold on to them and then just fill in the blanks when we need to?
So your broker will have a list of form addenda that they have, that they provide and that they have had approved by an attorney, whether that be me or somebody else. I don't have that because I review language for different agents and different brokerages. And so I don't keep like a master list based on each office, but your broker will have that for you.
Thank you.
All right, any other questions for me? We have a few minutes left, so I want to make sure if you have questions, we are getting those addressed for you.
Kristen, Bill again. I just want to clarify Cynthia's question. In today's email, Cynthia, from Veronica, there is this specific language that has been approved by Kristen, I believe, for that appraisal gap.
Yeah, I did see that email.
Right.
Thank you.
That language is in there.
Yeah, so you specifically, I know your broker has those addenda. I've approved a lot of them. I don't think I've approved every single one of them because some of those predated us working together, but I know that they're providing you ones that have been reviewed and approved by attorneys. So those are all safe for you to use. All right, any other questions for me?
What if we just get contracts that are, I mean, when we have multiple offers, it's kind of amazing sometimes. Like you might get 8 offers and like 5 are, you know, filled out either incorrectly or the blanks aren't in there. So usually, right or wrong, I mean, when I see that, that kind of like steers me away from those agents because I almost feel like, you know, if they can't fill out the contract correctly, how, you know, how good are they going to be in the transaction? But with that being said, if their offer is the best, is that when we should just sort of counter back and almost like correct the contract for them?
100% yes. Almost all disputes that come across my desk over the contract the contract is not filled out completely or accurately or both. And yes, I'm probably seeing the worst of the worst because I only see the ones where there's an issue. I don't see the ones where you close without any sort of hiccup. So, but having an accurate and a complete contract is so important. I definitely encourage you to counter, even if it's just cleaning up the contract. You know, using a full legal description instead of a partial, checking boxes that maybe weren't checked or blanks that weren't filled in. Absolutely. Even though it's a counter, I would still recommend you do that to make sure you have a clean contract. I'm dealing with an escrow dispute right now, and this was actually on the CRISP contract. So the way the CRISP contract is set up, if you're not familiar, there's a line for the amount for the escrow deposit, and then there's two boxes that you can check. One says the escrow deposit is being made simultaneously with the signing of the contract. The other one says escrow deposit will be made within blank days, if left blank 3 days. So in this case, neither box was checked. So not that it's simultaneous with the contract and not that it's going to be paid within 3 days, but there was an amount entered for the escrow deposit. So buyers changed their mind, tried to cancel the contract. It was not an as-is contract, so they really couldn't cancel it. And now one of the major issues that we're fighting over is, did they have to pay an escrow deposit? And if so, when was the deadline? Because there is a default for not filling in the blank, but there's not a default for not checking any of the boxes, but the amount was filled in, so their intent was clearly to make the deposit. So that simple little thing, checking off the box, would have, I don't know if it would have avoided this case because there are other issues in this case, but that is one of the major issues that a judge is going to have to decide for us. The buyers are taking the position that we didn't have to pay an escrow deposit because there was no deadline selected. So just an example of why it is so important that every box be checked and every blank be filled out. Right, any other questions for me before we wrap up? All right, well, I will go ahead and give you a heads up for next month's Get Real. It is going to be, it's the first Wednesday, so it's going to be March 2nd, same time, 10:30. We will continue to do these by Zoom. I've attempted to do these hybrid, Zoom and in person in the past, and nobody shows up in person. So if that's something that interests you and you would show up in person, let me know. I'm happy to do it. But it seems like Zoom is the preferred method. And then I thought I would try something different as far as the presentation goes for our next Get Real. And I thought I would start a series of doing Martinez Law case reviews. So I'll pick a handful of cases depending on how lengthy, of real actual cases that we're litigating in my office, using those as an example to drive home a point like the one that I just did. And so you can see what, what are people fighting about? What do these real lawsuits look like? I know Cristen tells us not to do this because you could get sued. Well, here's an example of an actual lawsuit and here's how it came about. So we will do that for next month. And if it's interesting to you all and you get value from it, I'll continue to do those because we have plenty of cases that we can go through as a case review. So that will be next month, March 2nd at 10:30 by Zoom. Again, thank you all as always for attending. If you have any questions about today's event or anything at all that I can help you with, feel free to reach out to me. My email address is in the chat, and you can reach out to us on our website, by phone, social media, any of those places. But thank you all so much. I appreciate you attending and I hope you have a great rest of your week.
Thank you, Cristen, for your time.
Yep, absolutely. Thanks.